Good afternoon. My name is Mary Meeks. I am a constitutional law attorney, and I'm here today because in 2010, I was asked by the mayor of Orlando to help draft a new prototype DPR ordinance. And I'm proud to say that we created a unique model that provides a bundle of 7 very important legal protections for domestic partner families. I have since worked with numerous other municipalities all around the state that have adopted the Orlando Model Ordinance and have literally seen thousands of Florida families register and be able to obtain those very important protections, from young couples with children to older couples who have been together for as long as 30, 40, and even 50 and more years. It has truly been a transformative experience for me because I have also seen the great pain and suffering that has been suffered by individuals within this state who have not had those protections when they needed them. The core principle of a DPR is that our society values families and understands that families need to be recognized as families and that they need certain inherent legal protections that protect the family unit. And I want to stress that the rights provided by a DPR cannot be duplicated by legal documents. That is a complete and utter falsehood. No power of attorney or other legal contractual document can give you the legal right to make sure that your partner is in the hospital room with you, nor that you have the right to arrange your partner's funeral when they die, nor any of the other rights that are included in the Model Domestic Partnership Ordinance. I have known many people who have had every possible legal document known to mankind and have still been denied all of these rights. The fact is that these important rights can only be provided by the government through the vehicle of a domestic partnership registry. And I applaud this commission for taking up this issue. It is a very important issue and it will help a great many people. I do have 2 specific concerns about the content of the proposed ordinance. My first concern is that it leaves out children. Number 1, the proposed ordinance has taken out a provision which would include hospital visitation rights to the children of domestic partners. That creates what I call my Brady Bunch scenario, where you can imagine you have a Brady Bunch family with an unmarried couple that has both brought children into the relationship and who consider themselves to be in a family relationship. Absent a law like a DPR that grants such rights, little Bobby Brady does not have the right to visit Carol Brady in the hospital, and that is a real shame. Secondly, the draft proposed ordinance has taken out a provision that grants the ability to participate in educational activities of a domestic partner's child. This would include simple things like the ability to pick up a child at school or to participate in a parent-teacher conference. The model ordinance simply grants to domestic partners the same rights of a step-parent in that situation. And it explicitly recognizes and in no way interferes with the legal priority of the biological parents. So it creates no conflict whatsoever with the rights of a biological parent, and in fact explicitly on its face grants a veto right to a biological parent.
Excuse me. Okay. When you're done, Commissioner Robinson has a question.
At the end, yes, I'd be very happy to take questions. With regard to those 2 issues, I think it is extremely important to include children in the DPR ordinance. That is the only way that you can protect the entire family unit. And so I would urge you to amend the current proposal to include these children rights as other DPRs have included. My second concern is with regard to the residency requirement, which is not included in the model ordinance and has not been included in any of the more recent DPRs. And that's because we've realized that it serves no purpose. The purpose of a DPR is to give protections to all people who are in Sarasota County. That can be full-time residents, part-time residents, commuters, tourists, friends and family members of residents. All those people go to hospitals. A DPR is just like other laws that protect people. Law enforcement doesn't just protect residents from crime, it protects everybody that is within the geographical boundaries of Sarasota County. The point being, if you are in Sarasota County, your families are protected. There's absolutely no negative consequences whatsoever from not having a residency requirement. I would urge you to remove that requirement of residency. Also to include, as I think I heard gladly, to include a reciprocity provision, because in that way you will be able to protect as many families as possible. Again, I'm very happy and actually would invite any questions that you might have about any issue that I discussed, anything about DPRs in general, or about the model ordinance. I've probably answered every question that could possibly be asked in the last 3 years, and I'm very happy to be here to offer any resource that I can.
Thank you. Commissioner Robinson.
Can you tell me where in Florida statutes or the name of the case that step parents are given rights to children's education?
It's actually a federal statute. I don't have the site for it. I can get it to you certainly between.
I've been asking this since December, so this is not a surprise to anybody. So I've been repeatedly asking for this. So it's been almost a year that I've asked for this, but. In the state of Florida, the only way that you have access to children is through being a parent, which is legal or biological, or by court order. And you're asking us to give, just by merely two people getting together and signing a domestic violence or domestic partnership registry, to give somebody rights to a child just by that mere fact. And I'm trying to understand how we can that, first of all, that's not the original reason why this came before us. This came before us as a denial to hospitalization and death rights. So this is completely different from why this originally came before us, the complaints that we've heard. So I'm trying to understand why two people who sign up for a domestic partnership registry automatically get rights to a children, when it's the only ways in the state of Florida you can do that are through court order or by being a legal or biological parent. So I've asked that, and I still haven't really gotten an answer to that. So I'm going to ask it of you at this point, because I can't insert that in without that answered.
I understand, and I appreciate the question, Commissioner, because I wanted more time to address it outside of the limitations. So first of all, I would say that I wasn't involved in initial presentations here, but the model ordinance that we passed 3 years ago and that has been passed, and I think every jurisdiction since then, has included the educational piece. So that's all I can say about that. And I want to be clear, when you're using the terminology about access to children or rights to children, the right that we are asking for is very specific. So I don't want there to be any misunderstanding that it attempts to in some way perhaps go beyond what is intended. So those very simple things like the ability to pick up a child after school, at the end of the day.
It says educational decisions. I mean, it's not a right to pick up a child. It's a little bit different, and you can sign a piece of paper for that.
I understand. So I was going to put it into two different categories. Right, so there's two categories of rights that this would affect. One category are very simple things like that: the ability to pick up a child, the ability to be a chaperone at a field trip. The only ones that, as far as I know, have any legal implications are the ones where it requires access to confidential information of the student/child, such as a parent-teacher conference or having access to the student's records or medical information or something like that. Okay, that is where you're absolutely right. There is a priority legal right of a biological or, by adoption, legal relationship to the child. But there is a federal statute. I don't have it with me. I will get it to you.
I got it right here.
Oh, okay, well, then your colleague has it.
It doesn't say what you said, though.
Well, it doesn't use the term step-parent, but it provides an exception to that privacy concern. It allows a biological or legal parent to designate someone other than another biological or legal parent to have access to that confidential or private information. It also includes a specific exception. It says the biological parent can basically veto that designation. And so when we drafted that piece of the model ordinance that covers educational participation in educational activities, we specifically included that very explicit language on the face of the ordinance that specifically says we grant this right, but the biological parent has the right to veto it. So if the other biological parent or legal parent doesn't agree, all they have to do is object, and it doesn't happen. But this would allow, in situations where there is no objection from the other biological parent, for a domestic partner to have the ability to participate in those kinds of activities and decision makings with regard to a domestic partner child.
All right, I'm not going to go any further with that aspect of it.
Yeah, I think you better, Madam Chair.
Commissioner Barbetta.
I've got up the federal, it says here, the Family Educational Rights and Privacy Act, FERPA, and it deals with the federal law concerning family compliance on education. And it says FERPA gives custodial and non-custodial parents alike certain rights with respect to their children's educational records, unless a school is provided with evidence that there is a court order or state law that specifically provides to the contrary. So this only relates to records, educational records, number one. And number two, if the state of Florida's law is contrary to it, that governs according to this, because it's saying it's subject to court order or state law. So I'd be a little careful, unless you got another statute that saying that it automatically gives rights, that a DPR is automatically going to give rights to full educational decision-making with regard to children, because I think Commissioner Robinson's right. I don't think that's there. And if you got another citation, fine. But this is the one I found relatively quickly regarding federal law and children's education, and it strictly relates to the records.
You're right. That is the law, FERPA. And
that has nothing to do with the decision on education and et cetera. It's the records, child's records.
Well, and I'd have to refer back to the actual language, number one, of the model ordinance, which obviously you guys could craft it, narrow it in any way that you want. I don't think that the model ordinance actually says decisions. I think it says activities. But if you're more comfortable with activities or even more limiting language, the intent of that provision is to, number one, address what I think and hope would be non-controversial things, such as you can designate a domestic partner to pick up your child at school, which does not implicate any confidential or privacy rights whatsoever, or to chaperone a field trip that the school may participate in. So it's only in those contexts, potentially, although not necessarily, of a parent-teacher conference or some other situation where those confidential records and the contents of those records, which is what I think is exactly what's covered by FERPA, is implicated. And so there is an attempt to create an ability for a domestic partner to be able to participate in those kinds of activities that would, by definition, require access to the confidential information, but also explicitly allowing the federally recognized exception that the biological parent can veto that if they want to. So I completely understand the concerns of the Commission. This issue has come up with other boards. So far, every other board has approved and adopted that piece of the legislation. But I understand the concern, and I would be happy to work with any one or more of the commissioners on the board to help craft that language in a way that hopefully would eliminate the concerns that you have, that would grant those rights that hopefully nobody has an objection to, but that you're completely comfortable is in compliance with both the state and federal legal requirements. That is the intent of that provision.
Commissioner Hines.
Yeah, just one quick comment, and maybe I don't know if you want to follow up on it, but as a licensed attorney in the state of Florida, which you are, correct?
Absolutely.
Okay. Just to so quickly dismiss Florida statutes in regards to power of attorneys and healthcare surrogates and basically say they don't get you what you need. One of the concerns that I've expressed, and I think other folks on this board have said, this is an added layer. Do not skip those other rights. And your initial comment was, well, other than funeral, I disagree with your view. The funeral issue is one that's left out in those. But to basically, in my view, lead people to this domestic partner registry and say they're safe, you don't need power of attorneys, you don't need health care surrogates, they don't get you what you want, I think it's a disservice to the public. And so when we crafted this, there's language in this ordinance that talks about you need to talk to an attorney and don't purely rely on this. And so someone who's practicing in the state of Florida to say that and basically say the state of Florida doesn't provide protections, I find that hard to believe is credible testimony.
Well, first of all, I would agree with you that as an attorney, I would and do recommend to clients that even if they have the ability to register with a DPR, that they do both. I would completely agree that even with a DPR, there is no way for a gay couple or a straight domestic partner couple to replicate the rights that we're talking about. It simply it can't be done. So what we are trying to do is craft, if you will, a patchwork of contractual documents, the ones that can be done, that do procure some rights to some extent, and to attach to that these inherent legal rights that only a government can do, and which we're asking this government to do. So I would never tell anyone not to do the documents if they're registered. I think even with both, there's still some gaps in protecting domestic partner families from these kinds of situations. But I do still absolutely believe, and I've seen it in practice, so obviously, at least the funeral instance, you can understand.
Thank you for clarifying that. That's what I wanted
Absolutely.
to make sure.
I mean, obviously, a power of attorney dies when I die, so it cannot convey any rights whatsoever after that occurs, so that certainly eliminates covering the funeral situation. But I would still completely confident that there is no power of attorney or any other document you can execute that would force a hospital to allow your partner into the hospital room with you. Can't be done. It just can't be done. My partner and I can execute a contract that says if I'm in the hospital, I want my partner to be in the room with me, but it's the hospital that has power and authority over that. And the only way to ensure that right is for somebody, this board, to tell the hospital that they have to allow it. Cannot be done with a power of attorney. The emergency notification simply cannot be done with a power of attorney or any other possible legal document. Again, I can't execute a contract with my partner that makes the sheriff's department contact me if she's in an emergency. I could go down the list. The only one of these 6 rights, and if we include the educational piece, 7 rights, that is even remotely possible to be executed by document is the healthcare surrogate, which is provided by Florida law. The reason that we include that in this package is, number one, it's probably the most important. It's the one that's going to happen to everybody at some point in their life, and they're going to want that person who is the most important in their life to be making those decisions. And unfortunately, what we have seen in this state time and time and time again is that for some reason, even when couples do execute that form, which is available and authorized by Florida law, it's not honored and recognized, particularly for gay couples. And so again, I want this board to know, and I could stand here all day and give you personal examples of people who have had powers of attorneys and wills and living wills and designations of pre-need guardian and designations for hospital visitation. And every document that any lawyer like me or you or anybody else in this state has ever thought of, you can walk into the hospital with that whole stack of executed documents, and you still won't be given the right to make medical decisions for your partner because somebody might say, it's not the right form. It hasn't been updated. That's not a current address. There are so many ways. So number one, you're putting those people in a position of having to, number one, know they need that document because they don't have the inherent right. They have to go find a lawyer and pay for that document. They have to hope that the lawyer does it correctly. If they move or change their name, they have to do it all over again. They have to carry it with them 24/7. Obviously, that document does you no good if you're in an accident and get taken to the hospital and you don't have that piece of paper on you. And then you have to hope that if you do all those things right and you're in the hospital in that dire situation, that there's not somebody on that medical ward that says, I don't like gay people. I'm not going to let that person in the room. I'm not going to let him make that decision. I'm going to make up some reason why I'm not going to honor it. I've seen it happen personally. I have witnessed it, and I know many people, including personal friends, who that has happened to. And so we include that particular right in there, which can arguably be done by a document because we've seen so many times how it has failed to do what it was designed to do.
Thank you.
And I see another hand.
Commissioner Patterson.
Yeah, I sort of hesitate to say this because I guess we could get into another big debate about it. But I don't want to mislead people to think that when we give them a nice little laminated card saying you are part of a domestic partnership, that we're going to court to enforce those rights for the people carrying the cards. If, in fact, the hospital or whoever says, I'm sorry, we're not going to honor that, that will still require hiring an attorney, a private attorney, to enforce what Sarasota County's enacted. I just want to make sure that's understood.
Absolutely, and that's one reason that we drafted the model ordinance the way that we did, is to ensure, because there were concerns, that the county is not responsible in any way for enforcing these rights. It is subject to private enforcement by hiring an attorney or not. I still think that's a huge improvement over the current situation. So again, I would...
Okay, I just wanted to clarify it.
Okay.
I didn't want to, enlarge into a huge conversation on it.
Okay. The point being, it still puts people in a much better position than they're in currently.
Thank you.
Thank you.
Any other questions? I'd be happy to answer. I did have one final point I wanted to make, just because it relates to...
Only if you're very brief.
It is very brief and it's technical. The red line revisions that were recently, I guess just recently produced today, that relate to the termination provisions, and specifically the automatic termination. It provides, among other circumstances, that the partnership automatically terminates in the event that one of the domestic partners dies. One of the improvements that we've made to the model ordinance is that in that section we've added an explicit exception to account for the funeral rights provision. So obviously in one place this says if your partner dies you have the right to make funeral arrangements. This provision on its face says if a partner dies it terminates the domestic partnership. And so I would encourage just hopefully an amendment that would simply say, with the exception of the rights provided in the funeral rights provision. Thank you. Thank you very much for your time and the extra time and the questions. I appreciate it all.